Hello, it's Philip Taylor from Richmond Green Chambers speaking. I'm talking about a book I use called Cook on Costs. You can see the Flickr reference here, and this is the book itself. It's from LexisNexis Butterworths. This is the 2009 copy, because it's now published every year. It's given the longer title, A Guide to Legal Remuneration in Civil, Contentious and Non-Contentious Business. And it follows very much the way LexisNexis publish their books. You've got all of the usual introductory stuff at the beginning, cases and so forth, and statutes. Then we get into the copy itself, the chapter by chapter. It doesn't have paragraph numbers at the bottom, but it's laid out and written very much in the writing style of Michael Cook, which we've come to know over the years. And it starts off with the basic statements about costs. Then it goes into particular areas. There's a huge amount of detail, obviously linked now with the CPR. Then towards the back you have things such as the conditional fee agreements, funding, and the various changes that are taking place, with a useful index at the back. It's been very well reviewed over the years. There are lots of reviews at the front. All the main legal journals have commented on it. Do have a look at his preface at the beginning, because he actually covers in quite useful detail. I'm just looking to see where it is at the moment, but he covers in quite useful detail some of the points that we need to know concerning costs. That's the preface to the first edition, which explains why he wrote it. This was when he was a judge, and obviously we've got a more recent commentary for 2009, which I'm going to talk about. I've reviewed this in many journals, and I've given it something like Cooking the Books, or whatever it might be as a sort of term, as a pun. This year I've decided to give it the title, If You're a Practitioner, You Ignore Cook at Your Peril. And this is what I'm going to say about this year's edition, because as I say, it's a copy which you will see in many courts and robing rooms throughout the country, and it's well worth knowing of its existence if you don't already. It's very useful for practitioners obviously, but also for students, and I found it very helpful in the early years at the bar. And as I say, Michael Cook has a particular way with words which I rather like. It's quite amusing in places as well. Let's start off, and let me tell you what I said in the review. I've said, what does it cost to go to law? That's the question, because that's really what many clients want to know about. It sounds a simple enough question, of course, with the word a lot, or words a lot, being the obvious, obfuscatory, imprecise and dismissive sort of answer that you're going to get. Because the subject is one that bewilders the general public and confounds all too many practitioners. Therefore the work itself has continuing popularity and utility, and Cook on Costs, first published in 1999, is now in the year 2009 edition, which doesn't disappoint and just shows its relative longevity as a legal publication. Michael Cook explains in his current preface the following. He says, costs law, practice and procedure is a moving target, with a bewildering number of changes taking place within relatively short time frames. Like, for instance, right now, as I'm actually reading this out and giving you this video appreciation. He then goes on to say, can there ever have been so many investigations into the future of costs undertaken at the same time? Well, he's asking an interesting question here, because it's a rhetorical one with an obvious answer. It's not difficult to guess why Cook on Costs is published annually. Its regular annual purchase should be considered a necessity, in my view, by any solicitor who wishes to remain informed and keep up to date, and it will already be on the desk, of course, of many judges, as the Association of Law Costs Draftsmen Journal has put it so effectively at the beginning of the book in one of the recommendations. They're the people, of course, who should know, because we always pass the stuff as practitioners off to them. But we, as the advocates, are the ones who have to actually deal directly with the client immediately the decision is arrived at, and we've got to know what we're doing with costs as a result. There are a few better examples, therefore, of the moving target aspect of cost law than that of the conditional fee agreement, the CFA. That's sometimes known as no-win, no-fee agreements, which in principle I actually support because I present the subject for CPD. I do recognise that there are going to have to be changes. I'm not going to go into them obviously with this review, but I'm aware that certainly contingent legal fees and various other arrangements linked to insurance must be looked at in the future, but we'll look at that in a bit more detail in a minute, because with the legal aid budget being frozen at about 2.2 billion, therefore CFAs, which of course came in under a bit of a cloud and a lot of objections, they are expected to offer ordinary people with ordinary income some avenue of hope that they might be able to afford competent representation when the need arises. Obviously we'll get on to the reason why there are problems in a minute, like the success fee. The current government apparently takes a critical view, however, of CFAs, specifically because of comments by the judiciary, I would suggest, under the amount of the success fee that's given. It's obviously been evidenced by committees, academic studies and various other things which have been positioned, in my view, to snipe at them like ducks at a shooting gallery in your local fun fair. But it's all very well. With a frozen legal aid budget in the 60th year that it's been running, we've got to start thinking about what the future is for costs, because that's a crucial element of any person's case, and it's obviously what in many instances stops people exercising their rights. A recent scoping study, whatever that is, has been undertaken by Professors Fenn, Rickman and Moorhead to look into whether CFAs are operating in the best interests of access to justice, and Cook suggests that this is little more than a study about how CFAs should be studied. So don't hold your breath. Its outcome, he says, because it's fairly obvious to me that Jack Straw's indicated he's not too happy. The Conservative opposition have indicated they're not too happy, so something is going to have to give somewhere. So with reviews like this, the no-win, no-fee agreements are still obviously going on, but rumours are rife that they will be eventually restricted or got rid of altogether, with Jack Straw as the guy with the gun, if you like, blasting the CFA concept out of the water. Obviously more will be revealed, no doubt, when the results of the review of CFAs is undertaken by Jackson, and we actually have the final results. In the interim, Cook on Cost shines forth as a beacon of practical guidance to the complexities of all aspects of costs of contentious and non-contentious legal business. And for practitioners who are new to this highly readable and authentic work, it's not too heavy, 750 pages. Take a tour around its various segments which cover the main headings, and they're all sort of listed: solicitor and client, between the parties, quantification, the CPR. Obviously we've got particular types of funding, and I think it's quite important to bear in mind with Cook on Costs that it's always going to be there somewhere, probably in the court, because the judiciary do need to make relevant reference to it, and you should know your way around it, just as you do with, say, the criminal practice or the civil practice or whatever it might be. The Law Society Gazette says that Cook has succeeded in making accessible and even interesting a subject which most solicitors ignore at their peril. They're absolutely right, and I'm going to say it again. Thank you very much, Michael. We appreciate this, and thank you for the trouble of producing